First of all, thank you for inviting me. I'm delighted to see some people that I've known for quite some time. I'm happy to see so many people interested in the Nuremberg trials. In the United States, racial discrimination of the past and present are rarely thought of in terms of international law. Particularly, we talk about penal clause. So when we talk about hate crimes, for example, when we talk about unlikely reparations for slavery or the endemic racism coming out of discrimination, we tend to they refer to domestic standards and norms. And yet, just after the war, this isn't going to work. So from 1945 to 1949, experts from the American government have actively contributed to putting together the norms which would establish racial discrimination. Vous n'avez pas un pied de micro pour lui? And so some of the works on this topic are soon to be translated. But this was a brief parenthesis in the American history. So one of the major expressions of this passing internationalization was the prosecution of the 24 Nazi leaders, which was an entirely new and experimental judicial effort. So in my work, there are 2 points I want to make. We must conduct a sociography of the stakeholders, first of all. And so this is why I believe that a systematic study of the careers of the justices of the IMT, International Military Tribunal, is absolutely necessary. So there were innovations at Nuremberg, but I also wanted to see what were the individual backgrounds of the judges and prosecutors, because we must we must never confuse judicial practices with judicial concepts. So the category of crimes against humanity and genocide were in response to the racial policy of the Nazis. There was some very difficult work done around this concept, and yet it is occasionally absent from certain studies. So there is a link between the racial studies and racism in the U.S., and so I'll be looking at some of the different aspects that link the two and how institutional racism is considered in the United States. The speaker is reading a document which was not given to the interpreter, so I apologize. So, as I've said, this was a judicial experiment. The Nuremberg trials brought together practitioners, including American lawyers, who dominated the trials and gave it a certain tone. But there were other constraints or biases at work, which were ethno-racial in nature, and that is what I will talk about today. We can see this in the way the crimes were defined and for their punishment based on race. So Article 6C of the IMT, persecution for political or racial or political ideology are part of crimes against humanity, but it's restrictive because it doesn't speak of a individual crime. So it does not speak of conspiracy. And then the charge of proof is heavier because it would have to be proved that the extermination of the Jews by the Nazis had to be limited to the Nazi reign, and therefore nothing before 1939 could be considered. But the New York lawyer, Bernays, who was an expert at the War Department, and said that repression of racist crimes raises the problem of minorities. That's how he called it, the minority problem. So calling racial atrocities in the war could create a precedent to judge the conduct of states against their own citizens. This could open the way to huge political upheaval. Here, the question is to punish these atrocities if it is in the context of an attempt to achieve global domination. And so it was hostile to the idea of a more broader definition. And so it raised the fear that the Jim Crow laws and lynchings in the southern U.S. states would be covered by this international law. And there are many, many examples of the response to this. During the London negotiations in 1946, the Robert Jackson, the head of the American Accusations side, emphasized that the way in which Germany treats its own citizens is not our concern, no more than it is for another government to take an interest or interfere in our own affairs, where it might be considered that some of our minorities are mistreated. And so what we could see underway was this process of trying to neutralize the notion of racial crimes. What was going on here? First of all, after the war, the racial question for the United States was something that people tried to set aside or ignore. In 1944, efforts had been made to widen the scope of these laws. And in 1946, the fight against the Nazis was associated with the defense of the white race. And there are many other examples. Sidney Eidelman, a Southern lawyer, wrote in his journal, the judge is quite appreciative of Southern culture and particularly appreciates jokes about blacks. So the federal government had received reports. These experts were trying to legitimate the states' rights, and the defense of sovereignty means protecting the domestic, everything that is considered a domestic affair. Racism is a family affair, and it cannot be exposed to external international consideration. My second point, we mustn't be surprised that the American lawyers then adopted rather conservative positions, rejecting, for example, the Universal Declaration of Human Rights or the Convention on Genocide. But there is one very instructive case, and that is the Judge Jackson, Robert Jackson of the Supreme Court. So you can see the court here. and this is from 1953. We know that Jackson voted for the Brown versus the Board of Education of 1954, which ended segregation in schools, and we know he did this against his usual position. He found it difficult that the Supreme Court should eradicate fears, pride, and prejudice in society. That's not the role of the Supreme Court. And so, according to him, nothing in the Constitution prohibits segregation. And so, if we want to speak to those who suffer segregation, well, he also wrote, well, we must also take into consideration the people who must give up the segregation. So he has a rather interesting career, a very conservative judge. He was very much linked with upstate New York, Jamestown, where he began his career in 1934. He was close to Roosevelt, and then he became Minister of Justice. During his times in Washington, he was faced with the inflexibility of the Southern Democrats. When he was appointed a Supreme Court judge, he stood back, was not in the forefront on matters of discrimination. The Warren he tended to vote against affairs brought by black citizens. He was often undecided about questions of school segregation, and so he appealed to the white South. But he said to those close to him that this was a source of internal conflict for him. And in an opinion concerning the internment of Japanese citizens, American citizens, he dissented. After 1946, we saw a split in his opinion. And so, in the case of Jackson, he was very skeptical about the social role asked of the Supreme Court, and no doubt stemming from his close ties with the South. And so he carefully avoided drawing conclusions from his Nuremberg experience. In 1947, Jackson praised the work of the IMT when he spoke before the National Bar Association and spoke before the Black Bar Association. And he made no reference to the domestic racism when he congratulated Nuremberg on its decisions. Francis Rivers said that the principles of Nuremberg must be seen as a crime. All Americans must consider racism as a crime, as it was considered at Nuremberg. So Nuremberg was considered as a landmark for mobilizing people against racism. So this fight for civil rights could begin in earnest. So the NAACP in the 1930s had already started a work via test cases, picking some key cases that they hoped to bring as far as the Supreme Court, including in their work for the victims of segregation. As of 1945, they often pointed to the national treaties signed by the American government, such as the United Nations charters. And so the articles in the United Nations charters condemn racism sometimes the racial clauses in contracts were finally declared unconstitutional. But human rights so often in the United States. In their defense, civil rights lawyers were very familiar with the Nuremberg trials, but understood the limitation, their application in the United States. So, for example, in mobilization against lynching in southern states in September 1946. Well, I won't comment on that article, but the title says it all. Put lynchers on trial with Nazis, asks the DSC. So in September 46, so as the Nuremberg trials were ending, there were protests against lynchings organized by Paul Robeson in Washington, D.C. It was very tense between the organizers and President Truman. Racial discrimination in this country, according to participants, is as evil as Nazism in Germany. And the President Truman responded, domestic problems are domestic problems, and external problems are external problems, end of the question. And so it's true that the impact, here you can see Robeson in that picture, and so in the battle for civil rights, African-American organizations sent petitions to the United Nations, and those documents are amazing in several ways. They looked, there was an attempt to widen the scope and bring it up to an international level. And they were, in fact, even demanding an international court, such as the IMT. In 1951, William Patterson, a communist lawyer with the support of Paul Robeson, this 250-page work, the result of a very long study, is a long list of charges against the guilty. In the opening statement, it takes a model from the Jackson's opening at Nuremberg. It's interesting to note that this petition led to a very tense exchange with Lemkin. Lemkin was showing a lack of empathy for the African American cause, so this is of note. So to conclude, the Allies tried to reduce the racial question. So it was a trial under constraints. There was a desire to try to avoid this color line of the United States. And as we look at Max Weber's analysis, that there's a certain amount of irrationality going on here. Crimes against humanity creates a particular law for particular cases, and for this reason, we might find it very striking, this institutional position, and yet they were very much picked up by the civil rights movements. And so we can see a great disconnection with human rights in the broader sense. And so Nuremberg was really a parenthesis in the Americans' racial affairs. And so we mustn't have any illusions about this retrospectively, that the 1945 trials might have given them momentum, but it was nonetheless just the beginning.